Hi there, I'm Jim Zirin. Welcome back for a new season of Conversations. I can tell you from personal experience that when a trial lawyer reaches a certain age, the temptations to write a book are virtually irresistible. With us is Marty London, a lion of the New York trial bar, and believe me, they don't come any better. Marty has written a fascinating book entitled The Client Decides, A Litigator's Life, Jackie Onassis, Vice President Spiro Agnew, Donald Trump, Roy Cohn, and more. In the book, Marty discusses, what else, some of the fascinating high-profile cases he handled in a stellar career spanning almost 50 years. Marty, we're delighted to have you with us.
It's my pleasure to be here, Jim. Thanks for inviting me.
Now, congratulations on your book, which I found especially interesting. It's been critically acclaimed. Daniel Kornstein in the New York Law Journal says of it, quote, "A large part of what makes this book so enjoyable is London's easy writing style. He writes in a relaxed, conversational, informal voice, as if he were sitting in a bar with you sharing war stories. They make you think of the author as a pal." Now, did you intend to engage the reader in this way, or is that just the way you are naturally?
Well, the answer is yes and yes. I originally started out just to write a biography so my grandchildren should know where I come from. And then I launched into a description of my cases. And one of the early readers said, "It's too lawyerly." So I sort of sanded off the corners because I did intend to tell a story that non-lawyers would also find interesting, educational, and entertaining.
Well, you tell in the book where you come from, the Crown Heights section of Brooklyn,
yes,
corner
indeed.
of Utica and Schenectady Avenues.
That's me.
And you ask the question, it comes out of an old soap opera I used to do when I was a kid called Our Gal Sunday. How did the kid from Carroll Street between Schenectady and Utica Avenue in Brooklyn end up doing a tour of duty as chairman of Paul Weiss, one of the world's leading law firms? Now, do you answer that question fully in the book?
I do. At the end, I have a personal chapter, and I at least thought it was interesting, a lot of coincidences. First, right out of law school, I went into the Army for 6 months. Then I worked 3 years for a law firm that I didn't like, and then through a remarkable series of events, I ended up back in the Army when President Kennedy called up the reserves when they built the Berlin Wall. And before that, I got drafted a second time through some snafu. I went to an Army Reserve Center to straighten it out, and I met a young fellow who needed a shave, and he helped me tremendously. It turned out his name was Mario Puzo, who was then a journalism student who hoped someday to write a novel. And he helped me avoid a second tour of duty, and then he put me into a unit that got called up, and I did the second tour of duty anyway.
Well, did Puzo tell you about The Godfather in those days?
He hadn't written it yet. He was just
But it was
a
in his
student.
head.
He said he hoped someday to write a novel.
Yeah.
And I became quite friendly with Mary. He was a wonderfully warm guy, and he was tremendously helpful. But that interlude of my going back into the Army through a series of coincidences led to my going to Paul Weiss, where I've had a fantastic career. It was, as I said in the book, I won the lottery by finding that spot, and I've had a wonderful career there.
Yeah, well, you certainly have. Now, I'm always fascinated with titles. And you selected as your title, The Client Decides.
Right.
And that's based on something that the late Judge Simon Rifkin said.
Right.
We didn't, quote, "We do not decide what kinds of cases we try. The client decides that for us."
Right.
What do you think he meant by that?
Well, I tell you, Jim, when I first wrote the book, it had a tentative title, Saving Private London, which came out of my conversation and the help from Mario Puzo. And then I had an agent and I had a publisher. And the publisher said to me, "Well, you know, the problem with your book is it doesn't have a theme. I've had published books with surgeons and they're brain surgeons, or what's the theme of this book?" And I realized it reminded me of a Seinfeld bit where they're producing want to go to a show, and the guy says, "What's the show about?" And they say, "Well, the truth is the show is about nothing." So the theme of this book is that there is no theme. The theme of the book is we try cases that the client wants to be tried. So I've tried everything. I've tried matrimonial cases. I've tried civil cases, criminal cases. I even tried a terribly long antitrust case. There is almost an airplane accident case. There's almost nothing that I haven't done because that's what that client wanted done.
What goes into a consummate trial lawyer? What do you think the elements are in you that cause you to be so successful?
I think you have to have a passion for the work, because the work is really very, very difficult. Focusing on what you need to prove and how you're going to prove it and how you're going to examine and how you're going to cross-examine and what documents you're going to use is intensive work. And it's not something you can do as a hobby, at least not the way I did it, not the way we did it. You don't prepare for the cross-examination on the way down to court in the cab. You prepare for the cross-examination a month before you have to do it, so that when you come up to do it, even though the process was painful, you cross-examine that guy and you're in charge. Man, you know everything he's going to say, and you know everything you're going to say when he says what you know he's going to say, and you work it out so that there's no way out. And I've been, I have to say, very successful at that.
Well, many of our viewers think of a trial lawyer as Perry Mason, that you cross-examine the witness and he says, "You're right, Mr. London, I did it, I did it."
Right.
And, or you sum up before the jury and they're all in tears and they go out for 5 minutes and come back and say, "We agree with Mr. London." Is that what it's all about?
Well, actually, most trial lawyers have spent their entire life and never heard a witness say, "You're right, Mr. London, I lied." I actually had that happen virtually 2 times. One was in the Onassis case, in which the witness lied so many times. At one point, the judge interrupted the testimony and said to the witness, "You better go back, speak to your lawyer, because we're looking at serious perjury here."
And the witness was Gallela, the guy you were suing.
The witness was the plaintiff, Gallela, and Ed came back, and basically they read his testimony back to him, my cross-examination, and he said, "That's false, that's false." So that's as close as I've ever come to, "You're right, Mr. London, I lied."
You represented Jackie Kennedy.
I did.
And very effectively. You eventually got an injunction, which was modified later on appeal, but you got an injunction against Galella's harassing Jackie and her children.
Correct.
Did you really get to know her? What was she like? And what was she like as a client?
She was a wonderful woman, a wonderful mom, and a wonderful client. You know, I was a little concerned that I was going to represent someone who I feared might be a prima donna. I have been in courtrooms and had clients who paid no mind to me because they were hotshots and they thought they knew more than I did about the trial process. Not so Jackie. She listened, she obeyed. We prepared her relentlessly because there were thousands of photographs she had to look at. We sat with her from 9 o'clock in the morning until 5 o'clock in the afternoon every day. In our conference room, preparing her, and she was wonderful. She was really the kind of client every trial lawyer wishes he could have.
Now, you tried that case with Judge Rifkin. He was kind of your mentor.
He was indeed.
And tell us a little bit about Judge Rifkin.
Judge Rifkin was an absolutely extraordinary guy. He was brilliant, and he was as kind to his colleagues as you could be. My favorite Judge Rifkin story is I was an associate, and you know I was looking to become a partner, and so he and I were the trial team, and there was one very, very difficult witness whose name I won't mention, though he's dead. And I could never, my job was to prepare him, but I could never get him. He always put me off. make a long story short, while we thought he was going to testify in the 8th week of the trial, the other side put him on the first day. He was not prepared, and he was terrible. We walked out of the courtroom that day, and I knew my career was cooked because it was my job to prepare this guy, and I had failed. And the harshest thing he ever said to me was, Rifkin turned to me, Marty, and he said, Marty, you know, next time, let's prepare because it's more fun that way.
So he knew the value of preparation.
He certainly did.
Now, you haven't always been associated with the Democratic side of the aisle because you represented Vice President Spiro Agnew in all of his troubles.
Right.
Tell what that was like.
Well, you know, I was at that time, I was a Democrat. Indeed, I lived up in Westchester County, and at some point I was actually ran on the Democratic ticket for some local office, and I was chairman of the Ossining Town Democratic Party. But when my partner, Jay Topkis, called me up and he said, Marty, I've just had a fascinating telephone call. I said, what's that? He says, well, some guy called me up and he said, Mr. Topkis, can you come to Washington to meet a new client we'd like you to represent? And he's a very important person. And Topkis says, oh, is he a congressman? And the guy says, higher. I said, I can't mention his name. He says, a senator? He says, higher. He says, oh my God, a cabinet member? He says, higher. He said, oh my God, you mean the president? And the guy says, not quite so high. So I said to Jay said, Marty, is there any reason we shouldn't represent the Vice President of the United States, who is facing a bribery charge? And I said, are we going to get paid for this? He said, yeah. I said, then there's no reason we shouldn't represent.
So you had the courage of your retainer.
That's right.
So in a real sense, the client does decide. But let me ask you about some other representations you've had where you found yourself in opposition to two people very much in the news today, the first being Donald Trump,
right,
President of the United States.
Right.
Tell us that story.
Well, he wasn't the president then. I had a friend who was the chairman of a small law firm that represented tenants. And Donald Trump bought a building on Central Park South, and he wanted to evict the tenants and build something grander.
What year was this, Marty? Roughly.
I don't know. I'm guessing early 80s. It's in the book. And my friend's law firm did what they always did. You know, you seek an injunction on behalf of the tenants who wanted to keep their home. You go to the Corporation Counsel office and say, we think that he violated this rule or that rule. And he called me up. He was not successful, by the way, in the beginning. But he called me up one day and he said, you got to help me. I said, what is it, Rick? He said, my bank just called. They've seized my account. They've frozen my account because I'm being sued for $105 million by Donald Trump, who accuses us of RICO, which was a frivolous application. And
it's a racketeering statute.
A racketeering statute that said that my clients, because they made all these court applications, were racketeers. Now, there was no evidence and no suggestion that they did anything corrupt. Nevertheless, Trump begins by suing him, and he serves the complaint by serving it on the New York Post. Mm-hmm. So they read about it in the newspaper, and he says, now they'll learn I don't like to be pushed around. And he says, you know, rich people have a very low tolerance for pain. Mm. So we got an immediate conference with the judge. We got the complaint dismissed. We went up on appeal. We won 3-0. And then we brought a proceeding under the federal rules to sanction the other side.
Sanction the lawyers or sanction Trump?
Both, the lawyers and the client, especially the client, because the client had made all those statements, and we wanted our legal fees, and we got them.
Well, pretty good outcome for the client, I should say,
yeah,
but you saw two things in operation. One, a tactic of counterattack.
Yep.
Which Trump has adopted as a signature characteristic.
And is proud of.
And is very proud of.
Right.
And the other is the press release in advance of the litigation, which was actually, they used it in the government's discrimination case against Cohn in the 70s, against Trump in the 70s, where Cohn represented him. Now, these are both vintage Roy Cohn tactics. Now, did you see that connection? Because you also found yourself in opposition to Roy Cohn.
Right.
Not too long afterward.
Right. Well, Roy Cohn was not involved in that lawsuit, at least on the papers. He may have been giving advice.
I think actually it was in '86 when Cohn was sick, and that's probably why he wasn't involved.
Well, that could be. But my involvement with Roy Cohn was when I had served on a Bar Association committee called the Grievance Committee, which disciplined lawyers. And ultimately, the presiding justice of the Appellate Division appointed me to the chairman of the disciplinary committee. And when I took over the committee, I found that it was really in disrepair because it didn't have enough people and they couldn't really handle the big cases, one of which was Roy Cohn. And I said, you know, we're making a big mistake. The big cases are more important than the little cases. And we prosecuted Roy Cohn. And when my time was up, they asked me to serve again. And I said, no, I don't want to serve again, but I want you, Judge, to do me one favor. I want you to make me the acting chairman with respect to one case, because I'm staying with the Roy Cohn case. So the petition that disbarred Roy Cohn is signed by Marty London, acting chair of the disciplinary committee, and we got him. He was disbarred.
Now, how long was that proceeding pending?
5 years. It took 5 years to disbar. I said that. I think it was 5 years because he was represented by very good lawyers. They kept going
Michael
up to
Mukasey, who became a federal judge and Attorney General of the United States.
Absolutely. And they went up and down the appellate division. It was an extraordinary case. But in the end, the appellate division agreed with us 100%.
Now, when Cohn lost the case, and I think Donald Trump was one of the character witnesses.
He was indeed. He was
Cohn.
indeed. Who swore that he was a man of great integrity.
Great integrity, despite the various frauds on his clients, and he stole money from clients and all the other parade of horribles.
Forged document. He was an awful person.
Awful person. And Cohn said that the people who brought the charges against him, including you, were simply left-wingers, deadbeats, and a bunch of yo-yos, just out to smear me up. What McCarthy was accused of practicing is actually being practiced against me, i.e. a witch hunt. Now, we see the same type of reaction on the part of Donald Trump.
Well, listen, he was trained. They were very tight. Though my association with Cohn had nothing to do with Trump, and my adversarial attack on Trump had nothing to do with Cohn.
You're also very well known for your involvement in First Amendment cases, notably free speech cases, to some extent freedom of religion cases. And those issues are very much in the news these days, also with the kneeler situation at the NFL and the locking of arms and of professional sports figures. What's your reaction to that? Is their conduct covered by the First Amendment?
Well, their conduct is covered by the First Amendment insofar as they're perfectly free to say whatever they want, and they're perfectly free to do whatever they want.
They're free not to rise for the national anthem?
Absolutely. I have, difficulties with that because I find the national anthem and the flag to be very powerful and emotional symbols to me. I'm a child of immigrants, and I feel very emotional about those things. And I wish they would find some other way to express their views, but they're totally free to do that. I feel it's the same as, I was vigorously opposed to the war in Vietnam and supported most anti-war activities. But I wished that the anti-war activists would not have burned American flags. I wish they had found some other way to demonstrate their passion.
But the Supreme Court, led by none other than Justice Scalia, said they had a constitutional right to do that.
Absolutely, they could burn the flag. And my own, political view is that this is not buffoonery on Trump's part. This is an intentional, wicked, divisive maneuver to stoke up this conflict. And those people who say, well, he's doing it just to feed meat to his base, they're wrong, because he's appealing to people well beyond his base, because these are important icons.
Appealing to their sense of patriotism.
Yes.
But what do you think the players are saying?
You know,
why is it political speech?
It's political speech because they're saying that we are not getting the freedom and the equal treatment we're entitled to under the Constitution. And I believe they're right. I don't think there's any question that the police and various elements of our society are mistreating people of color. And they're entitled to say so, and they're entitled to protest and do what they can to see that it comes to an end.
Well, when this whole thing started, there really wasn't much ado about it. You had Colin Kaepernick.
One guy,
and maybe Michael Bennett of the Seattle Seahawks joined in later, but really Trump stirred the whole thing up, didn't he?
There's no question. He took a small item and made it into a very, very large national dispute, and I think it was intentional, calculated, and in some respects brilliant.
Well, you say, you mean brilliant as a political tactic from his standpoint?
On his part.
On his part. Now, you say that they had a constitutional right, the players had a constitutional right to do what they did, but you've also written in your book that you believe there's certain limits to the First Amendment, and you handled a case like that involving doctors who were targeted for murder because they performed abortions. Why don't you tell us a little about that?
Right. My firm represented Planned Parenthood and a group of physicians. And the circumstances were that early 90s, a physician was killed by anti-abortion protesters. And they posted a wanted poster of him, and somebody then shot him. Then his replacement got postered, and he was shot. And then another guy got posted, wanted, just Old West.
And who did the postering?
Anti-war activists who believed...
You mean anti-abortion activists?
Anti-abortion activists who believed that it was okay to kill physicians because physicians committed abortions and therefore were killing children. We sued on behalf of these physicians a group out west in Oregon who posted 13 of these posters and who basically urged people to go out and kill physicians. And we won the biggest jury verdict in the history of the state of Oregon. These people were enjoined. They went up to the circuit court. And the First Circuit Court overturned it. They said, no, this was First Amendment protected speech. And the court, and it was really abortion law, not First Amendment law. They said, oh, even though it's a horrendous thing, encouraging people to commit murder and making it more likely they would commit murder, that's protected by the First Amendment. Three judge courts said so, ultimately en banc.
En banc means the full bench.
The full bench. Actually, that court has so many judges that you have to get half of them en banc.
Get them all into a room.
And I forget what the vote was, or 6-3, I think, of the judges who were not involved in the first case said, no, 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 no. This is a threat, and threats are not covered by the First Amendment. But it's a close First Amendment case. It shows you it was right on the edge.
Well, there was a freedom of religion issue there, too, because they felt they had a religious right to target people who performed abortion.
Well, you know, look, that turns into the question of, do you have the right to target? There's an argument today that you have a religious right not to bake a cake for a homosexual couple. Well, but there's no religious argument that said, well, if I don't like what he's doing, I can kill him. That's not a religious argument.
Or that an Indian can ingest peyote, which is illegal because it's part of his religion.
This is way beyond any of those nice little distinctions.
And so we have no hate speech laws in the United States, do we?
Correct.
The way that we do in Canada or Germany. Do you think we should?
No, I tell you, I wrote an op-ed piece once that the Times took in which I think I would be in favor of controlling some speech that we don't control now, such as there's an organization that publishes how to make bombs to kill people. It was an organization that once wanted to publish the atom bomb secrets. I don't believe that a terrorist has a freedom of speech right to post a recipe for making a bomb that killed and wounded so many people in the Boston Marathon. I think the government ought to stop that.
Full stop. We've come to the end.
Right.
It always goes fast when you're having a good time. So I have a question for you, Marty London.
Go ahead.
Is the way to win cases to be a great advocate or to be on the right side? Does the client decide?
Well, the way to win cases is to work, and to be on the right side.
All of the above.
All of the above.
Marty London, thanks so much for coming by.
My pleasure, Jim. Thank you for inviting me.
Marty London, the client decides. And thank you for coming by. Tune in next week for more conversations. All the best and take care. I'm Jim Zirin.